Good afternoon. I'm Tara McInnes and I'm a partner at the Burnside Partnership. I'd like to welcome you to the third in the series of Emerging from Lockdown. This video is on claims against estates and the impact COVID will have on these. First, I'd just like to say a few words about the Burnside Partnership. We are a specialist law firm with a team of experts advising on private client, contentious wills and estates, tax and trusts. This series, Emerging from Lockdown, takes three topics: wills and probate, lasting powers of attorney, contentious wills and estate. And for each topic reflects on what challenges have lockdown created, what's been learned and what's changed, how might those lessons and changes be applied as everyone emerges from lockdown, and as we all hope, normality resumes. As I said, I'm a partner in our contentious wills and estates teams. I have been qualified for 20 years and practicing in this very niche area for approximately 10 years. I specialise in all types of claims against estates, including challenges against wills, claims under the Inheritance Act, proprietary estoppel matters, disputes between executors and trustees, and essentially the whole raft rectification claims also. Today I'm going to consider whether there is likely to be an increase in will challenges or claims against estates as a result of the lockdown or the pandemic generally. I will look at two different types of claims, and these are claims under the Inheritance Provision for Family Independence Act 1975 and challenges against the actual validity of a will on various grounds. So first of all, is there likely to be an increase in the types of claims? Well, a study by Direct Line Insurance in 2019, so pre-pandemic, found that a quarter of Brits would challenge a loved one's will if they were unhappy with it. So that equated at the time to 12.6 million people. As Kate pointed out in one of our earlier presentations, the number of deaths associated with COVID as at the 27th of April 2021 was 127,451. And the Office of National Statistics has said that the number of deaths in 2020 was 77,161, higher than it was in 2019. So if a quarter of those resulted in a challenge, then this would represent an increase of circa 20,000 claims. I'm not for 1 minute suggesting that there will be an increase of 20,000 claims, but it gives you an indication as to how these are likely to increase. It's not just the death rate which causes people to be more willing to challenge wills and estates, but also a result of an increase in property values and also a rising awareness that they can bring such a claim. There are two distinct ways people can claim against an estate. The first is under the Inheritance Act, a claim on the grounds that the will or intestacy has failed to make reasonable financial provision for the applicant and that they have a need for maintenance. The second is an actual challenge to the validity of a will. The types of people who are eligible to bring claims under the Inheritance Act are a spouse or a civil partner, a cohabitee, so a person living in the same household as the deceased prior to death, a child, which includes adult children, a person treated as a child of the family, a person being maintained by the deceased, again immediately prior to death, and they all need to bring claims on the grounds that they have a need for maintenance. When considering whether to make an award to an applicant, the court will consider each case on its merits, and in doing so, we'll look at the relevant factors under Section 3 of the Act. These are financial needs and resources of applicant, both now and in the future, the financial needs and resources of any other applicant, again now and in the future, the financial needs and resources of any beneficiaries of the estate, any obligations and responsibilities owed by the deceased, the size and nature of the estate. So again, does the estate consist primarily of cash? Is there a property? Are there shares? Any physical or mental disability, either by the applicant or any of the beneficiaries, and any other matter, which is a very kind of a catch-all ground. It's the Section 3 factors that in all probability will be impacted by the lockdown and the pandemic. The applicant needs to demonstrate some form of a financial need for an award to be made. The likelihood is that the lockdown will increase these types of claims for the sole reason that it has impacted on people's financial situation. Some applicants might have been omitted from a will, because at the time the will was made, they were well off and could provide for themselves. By way of example, an adult who has their own property, is married, who has a good, well-paying job, their parent might have left them out of the will because they can look after themselves. The situation, however, could have changed in the last year because of a loss of employment, an inability to work as a result of illness, or because they've been furloughed. The court will consider the applicant's financial position as at the date of the trial, so not the date of the will. So if there has been a material change in circumstances, it's the financial circumstances at the date of the trial that the court will consider. There are likely to be more applicants, again, because of the financial impact of lockdown. Beneficiaries are also likely to have increased needs. Although, consider where you have an elderly spouse who has been retired, her needs might not have changed much, whereas some of the applicants who've been left out of the will, they might have lost everything. So you can see how that will impact on claims. Any obligations and responsibilities of the deceased. So the deceased might have incurred obligations and responsibilities immediately prior to death as a result of COVID, as a result of the lockdown. So maybe the deceased started to look after a child or a partner. The size and nature of estates, well, that can have changed because of lockdown, because of the delay in being able to sell house prices. That might have increased amount of capital gains tax. House prices might have increased, they might have decreased. If the deceased was in financial difficulty prior to death, they might have sold off a lot of cash. Alternatively, if there's been a business that's not been able to trade because of lockdown, that will impact on the size of the estate. Physical, mental disabilities. So the impact of COVID and long COVID, we don't know what those impacts are yet, but suffice to say that they will have an impact on health, physical health, and also mental health. Lockdown can also maybe have caused or exacerbated people's mental health conditions. The court can also consider the conduct of all parties, which might include how the applicant or how any of the other beneficiaries cared for the deceased during lockdown, or vice versa. So the other type of claim against an estate is a challenge to the validity of a will. A will not be valid if it does not comply with the formalities of the Wills Act. If the testator lacked sufficient testamentary capacity to make the will, if the testator lacked knowledge and approval of the will, whether wills long and complicated, predominantly seen in homemade wills, where there are suspicious circumstances where the will was prepared, which again might happen where homemade wills are prepared during lockdown. Alternatively, undue influence, where someone has forced the testator to make a will, coercion, or fraud and forgery. And in all of those circumstances, if they're upheld, the will not be valid. Usually where a will is prepared by a solicitor, it will comply with the formalities of the Wills Act, and I don't often come across wills challenged for a lack of compliance with formalities. However, I do believe this is set to change. Early on in the first lockdown, it became clear that the witnessing of wills physically was going to be difficult because you need two witnesses to the will to be present when the testator signs. And with the lockdown, that was always going to be an issue. In September 2020, a statutory instrument was introduced to amend the Wills Act to enable wills to be witnessed by video for the period from 31st of January 2020 to the 31st of January 2022. So we've still got until January of next year. If a will is not correctly witnessed, then it will not be valid. Many firms welcomed the amendment to allow for electronic will witnessing, and there will have been many clients who use this process to make a will, especially where they were ill or they were isolating. However, I mean, I'm not going to go through the requirements in detail, but there are strict rules which apply where wills are witnessed by video, and if they're not complied with correctly, then this will invalidate the will. Testamentary capacity is another ground for challenging the will. Where a solicitor has concerns regarding a testator's capacity to make a will, then they would usually get a GP to assess, or an assessor to assess the testator's capacity. Again, in lockdown, this might not have been possible. And whilst there are Zoom capacity assessments, they are available and they can be very good and very thorough. there might be cases where it's just not possible to pick up on the subtle signs of a lack of capacity over a video link. The recent case of Clitheroe and Bond seems to suggest that the courts will consider a strong grief reaction to be capable of causing a lack of testamentary capacity. So consider what impact maybe one or two members of a person's family dying because of COVID, maybe in quick succession. Consider the impact that might have on the testator's capacity to make a will. Other issues which might make electronic witnessing difficult, or Zoom capacity assessments difficult, especially in elderly clients, are obviously issues with sight, hearing issues, and technology issues. Another grounds wills can be challenged on is undue influence. So where a person has exerted influence on the testator to coerce them into making a will or leaving them a legacy, these types of challenges might be set to rise as a result of lockdown, with family members and the exclusion of other family members. In these types of claim, evidence is key, and the testator is no longer around to provide evidence. So where it's all happened behind closed doors, the evidence is unlikely to exist. So they're going to be very difficult to prove. The same could be true for fraud or forgery. Again, these types of offences are much easier when a person's been isolated from society. So to conclude, I believe that there will be an increase in both will challenges and claims against an estate, mainly as a result of the rise in the death rate, and also the increase in people's being in straitened financial circumstances, but also because of the other complications brought about by the lockdown, which I've identified. So whilst you can never completely prevent a claim being brought against an estate or a will being challenged, clients can take steps to try and prevent them or to limit their success. So, for example, where any wills have been hastily prepared during lockdown and it's still possible to do so, so the testator still has capacity and is still alive, then those wills should be remade if at all possible, or at the very least reviewed. Where there's been a change in circumstances, maybe by an adult child, or maybe they've fallen on hard times, or maybe where they've been left out of the will, they've then fallen on hard times later, or maybe they were estranged and then later there's been a make-up. Again, the will needs to be reviewed, and the testator should consider their reasons for excluding people from their estate and whether those reasons are still valid. Consider whether they have more of a financial need than they did previously when the will was prepared. Essentially, keeping the will under review and update them whenever there is a major change in circumstances. Also, it's you can make a discretionary trust rather than leaving out an adult child. You can leave the adult child a small amount, which would mean they'd be less likely to bring a claim, or you could leave grandchildren an amount, which again means that their parents might be less likely to bring a claim. On a positive note, most claims against estates are settled by way of negotiation or mediation, and these have continued during lockdown. So there are always ways of resolving disputes without incurring the costs and stress of proceeding all the way to trial. And I'm always happy to discuss those issues or any claims free of charge with anybody who would like to contact me. And my contact details are at the end of the slideshow. So thank you so much for watching, and I hope you found something useful today. And please do go and watch our other recordings. Thank you.